Good afternoon. My name is Claire Schubert, and on behalf of the Gerald R. Ford Presidential Foundation, I want to welcome our audience members and send a very special thank you and welcome to the teachers and students who are joining us today as we explore the past, present, and future of the Equal Rights Amendment, something that was very dear to First Lady Betty Ford. I will turn the program over to our moderator in just a moment, but first, a couple of housekeeping notes. We will be recording today's webinar for later viewing, so please check the Museum and Foundation's websites for replay or to share the link with others. We will be taking audience questions towards the end of the program, so please use the Q&A feature on Zoom to submit your questions. And when you do, let us know who you are. If your question's coming from a classroom, we would love to know the name of your school and where you're watching from. But don't wait until the end of the program. Please ask those questions as they come to you throughout the program, and we'll do our best to address all of them before the end of the presentation. I want to be sure to thank the Gerald R. Ford Foundation, Library and Museum, our friends at the National Constitution Center and the Center for American Women in Politics, as well as the National Archives Foundation through the generous support of Maggie and Robert Beauregardie for their support of today's program. And now it's my honor to welcome and introduce our moderator for today, Ms. Ann Compton. Ann Compton has always been a pioneer as the first woman assigned to cover the White House on network television, and with 41 years on the air for ABC News, her longevity and impact are unparalleled. After retiring from daily coverage in 2014, Compton reignited her legendary career by returning to ABC to cover the 2016 political conventions, as well as accepting a fellowship at Harvard's Kennedy School of Government, focusing on media coverage of the 2016 election. Compton's career at ABC News spanned 7 presidents and 10 presidential campaigns. Assigned to the White House in 1974, she reported for ABC News broadcasts from Washington and around the globe, traveling with presidents, vice presidents, and first ladies. Ann, welcome and thank you so much for leading this important conversation today.
It is an important conversation, and thank you for inviting all of us. It was a half century ago this month that the Equal Rights Amendment to the United States Constitution passed the House of Representatives by 354 votes to 24. The Senate a year later, 84-8. So why is the Equal Rights Amendment still not ratified and part of the Constitution? It is a fascinating real life story with twists and turns and cliffhanger moments for the last century. We have 2 very rich sources for our conversation today. From the renowned National Constitution Center in Philadelphia, Sarah Harris is director of what they do best at that very honored nonpartisan institution. They educate, reach, and teach about what the center very modestly calls the greatest vision of human freedom in history, the U.S. Constitution. Also joining us, Kimberly Peeler-Allen, not just focused on women's political leadership, she's at the heart of it all. At the Center for American Women in Politics at Rutgers in New York State, she's been right there working on the inside with the names in the news you've heard, and she knows what's at stake over the years for women's political power. We want both of them to be able to take your questions as we proceed. So you have that little Q&A function down at the bottom of your screen, and we'll encourage you to use it. But first of all, Sarah, I'm going to start with you. It is not supposed to be easy to change this sacred document of the Constitution. Can you frame for us a bit of the history, the twists and turns of the past? Sarah?
Absolutely. Thank you so much, Ann. And thank you, teachers and students, for being with us today. So like Ann said, it's not easy to change the Constitution, right? And it's set out in the amendment process on how to do that. So we all know that the Constitution has been amended, right, several times throughout history. There have been 27 additions to the Constitution itself. And the process to amend the Constitution is established in Article 5. And this in and of itself outlines the amendment process. So I wanted to to share with everybody kind of what that process looks like, to understand the foundations of kind of what the Equal Rights Amendment has to have gone through over this time frame that Ann has set out for us. So like I said, Article 5 of the Constitution outlines the amendment process in general. And there's two parts to this process. There's the proposal part and the ratification part. So in the proposal stage, Congress can propose an amendment if it secures 2/3 votes in both houses of Congress. And this has been a pathway for every amendment to the Constitution so far. An alternative to that is for the states to ask Congress to call a convention for proposing amendments. So whenever 2/3 of the several states apply for one. Now, in the ratification stage, which I have a feeling we'll talk a lot about today, Congress can call on state legislatures or state ratifying committees for that part of the process. And state legislatures themselves have been called on for every amendment except for the 21st, which repealed prohibition. So another important part that I want to make sure I mention today too, as we kind of start off this conversation, is nowhere in Article 5 is there a time limit placed on this overall process. In one of the few cases where this time limit has been a relevant part of the amendment's story is the 27th Amendment. And again, as I have a feeling we'll talk about today, in the proposed ERA. In the 27th Amendment case, it was proposed as one of the original parts of the Bill of Rights, but it wasn't ratified until about 1992. So that's something we can talk about a little bit more later in the session as well. But after that, so we're talking like maybe early 20th century, Congress started placing time limits, which is normally about 7 years on proposed amendments. So keep that in mind, students, because that is going to become an important part that we're going to reflect on during this session. And like we said before, it's not an easy process, right? But the founders thought that it was necessary to kind of implement a process like this in order to accommodate what they saw as an ever-growing country. And if we consider, and I want you to think about this, especially as we start talking about the ERA, consider kind of the historical context around some of these amendments that have been added to the Constitution. And we see that they are oftentimes in response to big historical events. The Civil War, right, with the 13th, 14th, and 15th Amendments, social movements like the Progressive Era, right, and the 19th Amendment, which again, we will talk about today, and the Civil Rights Movement with the 24th Amendment. There's also things that we've learned over time, right, like setting presidential term limits with the 22nd Amendment after the 4 elections of Franklin Delano Roosevelt, or changes to the Electoral College with the 12th Amendment after the election of 1800. So it is important to keep in mind that it is an intentionally difficult process, but one that was created to adapt to an ever-changing world. And all of these kind of procedures, all of these amendments have been added to the Constitution as a way to really help the country kind of towards a more perfect union. So just kind of keep that all in mind, students, as we move through our session today.
Sarah, can you also explain exactly where the ERA is now? The time clock involved, the number of states, just so we know where this snapshot is right now.
Fantastic, I sure will. So there has been kind of as we move through the history of the ERA and when it's been proposed, it was first written, students, in 1923. That's where we get some of the original language for the ERA itself. But we're still talking about it in 2021. So why is that, right? So we can trace its time throughout history. But as we kind of talk about some more kind of current events topics and a current events timeline, we were waiting, the ERA was waiting for 3 states. It was 3 states shy of the 38 states necessary for full ratification. And so in kind of 2017 to 2020, they got those final 3 states. So in March of 2017, Nevada ratified as the 36th state. May of 2018, Illinois was the 37th, and January of 2020, Virginia was the 38th. Now, there are some pieces to this puzzle as well, right? It's not so easy to say that those 3 states ratified it, and so now it's good. So a large part of that issue is this timeline that we have talked about, right? This time frame of 7 years until we kind of have to start the process over again. So now some of the things that we're dealing with are if those 3 states and if their ratification of it actually does ratify the whole amendment. We're also talking about kind of 5 states who since 1972 have rescinded their ratification of the amendment, who have taken it away. So now the courts and kind of people in government are trying to decide where it stands with that. So on paper, it does look like there are the 38 states necessary to ratify, but we have to kind of deal with that topic and if those 38 states in reality are actually part of that ratification process.
Well, I want to speak to Kimberly now, because you have been engaged in these issues for a long time, an advocate. Why has it been so hard for this particular amendment? What are the political and social forces that have literally locked it up for 100 years? Kimberly?
Thank you so much for the question. It is such a pleasure to be here with all of you to talk about the Equal Rights Amendment and what it means for our country overall. And the challenge of why we are here almost 100 years after its first introduction, there's a lot of factors. I think a big part of it is that we are in a patriarchal society. When you think about our founding documents and who was and was not included in the Constitution when it was first written, it was predominantly focused on land-owning white men. And everyone else has been added to the conversation. So with that, we have had to really kind of use, as I like to say, string and duct tape to make our Constitution and the laws that cover our country really inclusive. So there has been a lot of conversations around who needs to be protected. If we give equal rights to women, does that mean that they have the ability to work as many hours as they want, that they have the protections of the law around pay equity, around domestic violence, life overall, and being able to be supported and protected by the Constitution? And what will that mean for the changing dynamic of our lives in America as a basically patriarchal society? It will definitely change things if women are then permitted and given the full protections of men for them to compete in the workplace, for the change in the dynamics, for a different level of accountability that has happened. But as we have moved through our nation's history, as I said, we've been using duct tape and string to pull things along. So there's also been this perception that we don't need the Equal Rights Amendment because we have all of these other laws that have gone through Congress to protect all classes of people. But the thing is, if we had the Equal Rights Amendment, we wouldn't need the duct tape because it would be soldered in steel into the Constitution. So I think there has been an ongoing conversation and debate about whether it is necessary, whether it is relevant, what the impact would be, and then with that impact, as power dynamics change, there is also going to be that pushback of from insurance companies having to redesign their actuary tables, to employers having to make sure that they are using equity lenses in their hiring and not holding women to a different standard than men, to the way that we treat caregiving in our society. All of these things are change, and we know that in general, humans are reluctant to change. We are resistant to change, but change is something that we all know is inevitable in this life. So I think that is part, in very broad strokes, why there has been such a challenge, why we are still here now, almost 100 years later, with so much more work to be done.
Well, I want to ask both of you now, let's look at the actual language. Let's start, Sarah, would you, or I can read, or you can read what the actual language is that's before the nation now. And it's a lot simpler than it was when, was it Alice Paul promoted a version of it, which is much longer and much more controversial. Could you read that, Sarah, the section 1 of the amendment as it stands now?
Sure. So I have here, let me see, I want to make sure because I tried to kind of find some of the language as it moved throughout history. So please, Anne, feel free to step in if I'm reading a version that's
Okay.
not the current one. So what I have here is equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex.
That is exactly what is on the table now. And that has actually been around for 50 years. That was proposed. The original Alice Paul one, let me read it for you because it's interesting. Her language was no political, civil, or legal disabilities or inequalities on account of sex or on account of marriage, unless applying equally to both sexes, shall exist within the United States or any territory subject to its jurisdiction thereof. Pretty legal. But the point, I think, is clear from her early language as well. You've got to treat men and women equally. Is the version that you just read that ends with can't be abridged by the United States or by any state on account of sex? Are there some people who would even like to improve on that language? Maybe we use the word gender these days as opposed to sex. Sarah?
So, Anne, thank you. So there is, obviously the words that we see in the amendment itself, they matter, right? And we've learned that through the years. The language that we see now is very similar to language that we've seen in previous amendments that are kind of expanding the rights here. So there has been talk, especially because this language, like you said, Anne, has been around for 50 years. How do we now adapt it to changing times, to adapt to our current culture and our current society and our current concerns? So I think that there is kind of this push of, is this as inclusive as it can possibly be? And I know that that's one of the arguments kind of about ratification now, right? That it has taken so long. When you look at the ratification timetable of other amendments, they are a lot quicker than what we're dealing with now, right? So again, with the exception of the 27th Amendment, which was over 200 years. So, how do we now adapt to this longer span of history? And how do we make sure that the language is as reflective of those needs as possible?
Of course, Kimberly, if anyone wants to change any of this language now, everything has to go back to square one. Is this something that can be handled by the courts, or is this language really what they have to deal with right now?
Yeah, this is the language that we have to work with, because otherwise we would have to go back through the entire process. We would have to pass through the House, pass through the Senate, get 38 states to ratify new language to be able to codify the Equal Rights Amendment into the Constitution. So there is a lot of argument, a lot of discussion. There was actually a hearing in the House Oversight Committee this past Thursday
Right.
about lifting the deadline. The House of Representatives has passed twice now a bill to lift and remove that deadline so that it would actually be codified into the Constitution. It has not been introduced. Well, it's been introduced, but it has not moved forward in the U.S. Senate to date. So this is a conversation, and it came up in the hearing on Thursday of why don't we just start over? Why don't we update the language and just start over? Well, it is no small feat, as we discussed at the very top of this conversation. It is no small feat to amend the Constitution as it is meant to be. What we also in the advocate space recognize that amendments to the Constitution are the floor and not the ceiling for the opportunities. As we look at all the amendments that coming out of the Civil War were then bolstered by the Voting Rights Act, the Civil Rights Act, and several other examples like that, where we have a floor to start from and then be able to expand. So for equality in the Constitution, we don't even have a floor yet. We have the right to vote, but beyond that, we need to bolster and really fortify that equality statement by our Constitution, and then be able to build from there. So then we can bring in more expansive language that we can really encompass things like the Equality Act that has just gone through Congress and has also been supported by the courts. So there is work to be done, but to say, oh well, let's just start over, it's not that simple, and will take at minimum another 7 years. And I feel like we've been waiting for so long. I don't want to wait another minute.
I do, before we start taking questions from our student audience, I do want to hit one more kind of glance toward the future with you, Kimberly. You talked about what would have to change, things like actuarial tables and financial considerations. What would be the practical effect for women in the United States if this does not ever become a part of the United States Constitution?
I think in the broadest terms, the daily effect on women is that for everything that every opportunity, every chance at equality, it will be a fight. As we are seeing right now in Congress, the fight over equal pay, the fight around paid family leave, paid leave overall. We have to, every several years, we have to recertify the Violence Against Women Act. These are things that should be no-brainers, should be just equal protections across the board, but we have to continue to have these fights over and over again to ensure that the tape and the duct tape and the string hold up, so that rights cannot be rescinded, as we're seeing in states across the country. That bodily autonomy is definitely part of the conversation, part of the discourse of what is happening in some places in this country, and thinking about how this also has a ripple effect around voting rights and our ability to be seen and heard in this country. And if it is not fortified in the Constitution, anything is up for grabs, and it also can go down to your experience and your sense of equality can vary depending on what state you live in, instead of it being across the board.
I am anxious now to start a little early on some of our questions that we are getting in from our audience. And just while you all are looking for that way to enter your questions, I've got to tell you, there are two moments in my own career. I was a TV correspondent covering the White House and national politics for long time, starting with the Gerald Ford administration. And there are two moments that really resonate with me right now. One was the first president I covered was Gerald Ford, and Betty Ford, his wife, I traveled with her coast to coast campaigning for the Equal Rights Amendment. She even, the women would, come out and support her. She had this wonderful little sign that someone made for her that she had on her desk there at the White House, where she would work the phones and work the issue. And it said, "Don't tread on me," which of course was a very early American phrase of defiance. But instead of showing a snake it showed pantaloons. And in her White House office bedroom, I think that's her son standing over there next to her. Her kids all really supported her work for it. The other thing is the fact that I was a local reporter in Virginia covering the 1970s, the first wave of states considering the Equal Rights Amendment. And in Virginia, a conservative southern states, where actually most of the Republicans were in favor of it, most of the Democrats were more conservative and against it. I covered the hearing in the House of Delegates, which was contentious and angry. I remember spitting being done at the committee. So then last year, to have Virginia, the 38th state to actually vote to ratify, it makes it very personal for me, because this was a state that was quite the opposite many, many years ago when I was there. So let's get to some questions, and I'll let both of you field these. Kimber, this one comes, it says, Kimberly mentioned laws preventing discrimination based on sex, that some feel it is good enough. Can you explain the difference between the impact of a constitutional amendment and the law? I'll start with you, Kimberly, but I know, Sarah, you have thoughts on this too. Kimberly?
Absolutely. So the what we have seen, particularly, I think everyone has a lot of sense over the last several years of the kind of ping-ponging that goes back and forth in Congress of passing this law and then we're rescinding this law, or we're passing a law that restricts some of the previous parts of these laws. The first thing that comes to mind is the Voting Rights Act, where the courts have struck down parts of the Voting Rights Act, and many people agree have weakened the bill, where if it is a constitutional amendment, you cannot weaken the argument. It is set in stone. So there is definitely a strong sense of I guess finality in codifying and amending the Constitution that is definitely there, but not for a law that passes through Congress that is kind of up to the whims of the courts and whichever party is in power in the House and in the Senate that can either pass laws that strike down different elements of the particular bill, or the courts can overturn a bill as being seen as unconstitutional completely. So there's definitely more of a variable for the bills and more concrete and steadfastness in an amendment.
Yeah, Sarah?
I mean, Kimberly kind of summed everything up so nicely, so I appreciate going second. But one additional kind of point to be made too is that part of this amendment process is that it spans all of the states, right? That all of the states are coming together to ratify this amendment, this proposal. And you don't need a unanimous decision by all of the states, but it is something that is more kind of far-reaching. And so that's kind of something to keep in mind as we consider this too. And the other thing to consider is that there are still kind of issues to be considered when you talk about these constitutional amendments. So I know that I was looking at some other questions that kind of came in the chat as well. And there are kind of, ways for people to look at the language. We talked a little bit about how important the language is a little bit earlier. And, the way to kind of interpret it and figure out maneuvers through that language too. A little bit earlier, Kimberly brought up the Reconstruction amendments, and how they even necessitated, more legislation later, 100 years later. So there is kind of all of that, all of that nuance to go through this as well, which good, bad, or indifferent, that's kind of what would happen with an additional constitutional amendment or additional legislation too.
Good point. I love this comment from Annette Bethel, who says, even Strom Thurmond was in favor of the Equal Rights Amendment, the conservative Republican or Democrat, then Republican from South Carolina. And I was surprised in doing some of my research for this that Eleanor Roosevelt was so outspoken against it. So this question comes in, what were the biggest arguments against ratification back in the 1970s? Was it that women should not be held to the same standards? Who wants to take that? What would be the biggest arguments against the ERA back in the 70s?
So I can speak to some of those original arguments back when Alice Paul first introduced this idea, and then Kimberly, feel free to kind of connect it to some of these, more modern day arguments around it too. But one of the things that I find the most interesting when we're talking about this is that the Equal Rights Amendment can be traced back, as one would imagine, to the Women's Suffrage Amendment. right? And how all of these ideas kind of went hand in hand. We know that Alice Paul first proposed her version of the ERA almost immediately after the 19th Amendment was ratified. But the women's suffrage movement itself kind of started with this idea of what's called coverture laws. And these are laws that kind of husbands assumed the legal rights and obligations of their wives when they became married. And so society didn't view women as equal and autonomous individuals, but as kind of part of this family that was governed by their husband. So the reason why I kind of want to bring that up is because a lot of the early arguments against the Equal Rights Amendment as it was proposed was that there was no room for protective legislation. So what that means is there were laws in the books that protected women, that protected women from working, tons and tons of hours during the week, or protected them from standing on their feet for all of those hours, or working in dangerous working conditions. So some of the arguments, at least in those early stages, were that if we accepted the language as originally proposed by Alice Paul, that laws couldn't protect women anymore. So again, take of that what you will, but one of the kind of clearest examples of that, and ironically, one of the examples that I love kind of talking about the most, is there's a Supreme Court case that dealt with this very issue. So students, what I would suggest, when I was in the classroom, I always had my students read this specific Supreme Court decision, and I would highly recommend you do the same. But just kind of overview of this case itself. There was a law, this case was from 1908, and there was a law that limited the hours that women could work, right? Saying that they couldn't work, over 10 hours a day, over 60 hours a week, what have you. A man who owned kind of a laundry violated this law, and he was taken to court for it. And the Supreme Court itself, using a lot of data kind of built taken from Europe that kind of proved that women were more frail than men and in need of protection by the state, the Supreme Court found that it was completely constitutional to limit the working hours of women because, in large part, they are child bearers. They're the ones that, and this language is taken almost exactly from the decision itself, which is why I highly encourage everybody to read it. So this was, a huge piece of protective legislation where the courts themselves, because women needed that extra protection from the state, were there to make sure that women were staying safe and that they were staying healthy. So that's really what a lot of these arguments were. It's kind of hard to consider what arguments against equality might be in this case, right? But in a large part, that's what it was, that there were women afraid that by passing the Equal Rights Amendment, that the law wouldn't be able to protect them anymore. So that's kind of where we were in large part, kind of in the early 1900s, and the mid 1900s, right after the ratification of the 19th Amendment.
Kimberly, bring us up to date. Are all of those still valid or still being used? And then I have a follow-up question for you coming in from the audience.
Well, it's not quite as antiquated language, but the argument in the 70s, and I think, and the argument that is not as loud as it was in the 70s, is that this will erode the American family, that it, in some have said, well, this will require women to work, and it removes their power to stay home and take care of their families, have children. That there is, in the 70s, there was definitely an argument around, well, this is going to erode the institution of marriage because women won't need to get married, and they won't want to get married because they don't need that protection anymore. So what does that mean for the fabric of America? There is that very much that conversation. I think now there is a lot of concern about what will this mean for the conversation around childcare? What will this mean for the equality of women in the workplace? And it also is shifting, prompting the shift, as we've started to see, around family leave and people taking paternity leave or family leave overall, and it's not just limited to the women. And it's very we're also seeing the need to really instill some true support for our families. And I think the pandemic in particular has really highlighted the stress that both mothers and fathers and all caregivers are having to withstand as they try to take care of their families, and the support that is not necessarily there from government because of, oh, well, we don't have an equality standard that everyone will have this care, that we will be able to make sure that people are getting paid, equal pay for equal work, and what that means for our economy and our ability to thrive and actually support our families.
Kimberly, let me share with you, ask you a question that came in from viewer Kelly Young Raymore. Do you think that states are afraid that this amendment will force them to recognize the rights of non-binary and trans people? That's a far more modern question.
Oh, absolutely, absolutely. As one of the many hats that I wear in the universe is also the chair of the Equal Rights Coalition, which is an organization of over 200 member organizations across the country who are continuing to advocate for the Equal Rights Amendment. And as we have been, marching around Capitol Hill virtually because of the pandemic, and talking to legislators and their staffs about lifting this timeline. One of the big conversation points now is, what does this mean for trans rights, and how are people, whether they are comfortable accepting, acknowledging of the rights of trans people and non-binary individuals, and what that means for society overall. And that is a big conversation point, and we have seen that there are some members who have said that they are concerned about this and will not support the Equal Rights Amendment because they don't believe, because of their personal experiences, that trans people and non-binary individuals should be privy to equality in this country. So the conversation around, what does this mean for the norms of our culture overall. So that it is definitely a conversation, at the federal level, at the state level as well.
I would throw in this, just a question from me, because in covering over the arc of 7 presidents in our country, starting with Gerald Ford, ending with Barack Obama, in my time at the White House with Barack Obama, some social issues have moved so fast compared to decades earlier, particularly the public acceptance of same-sex marriage. Do you think that the support, the public support for so much of this is really being affected by the digital age? Kimberly, let me ask you that support for some of the things that were once worries moving much faster in our society today.
Oh, absolutely. I think there is to the thought process that there is already equality in this country for women, is definitely an indicator of the perceptions and the culture overall, of some of these pressure points, as we have been trying to codify the Equal Rights Amendment. And there is the efforts around marriage equality, even going back to interracial marriage. These are the things that have really shifted the culture and the norms of the country. And I think there's the energy has been there, and I think the biggest challenge for us, though the energy is there demanding equality for all, is that there are so many who believe that it's already codified, that these protections are already there, that there is not that sense of urgency of we need to really do this, because of the misconceptions of the protections that are already laid out. So I think the biggest campaign, the biggest effort that we at the coalition and are doing is educating people about what protections we actually have in the Constitution and which protections we do not have in the Constitution, and how the Equal Rights Amendment can bridge that gap.
Okay. Did you want to add anything there, Sarah?
What I was thinking of as Kimberly was sharing was that we have kind of changed some interpretations of amendments that are already established, right? And so how that has kind of has played into the 1970s movement and things like that in response to the Equal Rights Amendment. So for instance, the 14th Amendment, when it was ratified, women tried to use that to gain the right to vote. When it was ratified in the late 1800s, mid 1800s, they tried to kind of use that language, the Equal Protection Clause, to say like this applies to us too, that this applies to us as voters right now. And they were obviously unsuccessful, right? That's why we have the 19th Amendment. The 14th Amendment is the first time that we see the word male in the Constitution. So that was a huge blow to the women's suffrage movement at the time. So that kind of changed. And we've seen, to speak of the courts and things like that, we've seen courts kind of read into the 14th Amendment that it now does apply to sex discrimination. And that kind of speaks to the point that Kimberly made about, there are these layers in place that we do have some protections based on, gender, because of kind of using other amendments. And the question does become, is that enough? Is that something that, needs to be explicit? I love that floor and ceiling metaphor that Kimberly used earlier. Is that something that, we need to make sure is explicit in the Constitution itself? But that was another kind of piece of the judicial branch where they were kind of reading that interpretation of the 14th Amendment that also kind of added to those extra layers during the 1970s.
I have a question that came in for Sarah, and we've touched on this before, but I think it would be helpful if you could expand on it. Question is there a precedent for this? Has an amendment ever been successfully ratified after its deadline? Could you revisit that for us?
Sure, I would be happy to. So there was one example where, and I kind of hinted at this earlier, but there was one example where there was an amendment that took an exorbitant amount of time. We're talking hundreds of years of time. So it was possible, but since that amendment was ratified, like I mentioned, they've kind of added specific deadlines, which is kind of at the heart of a big part of this debate for the Equal Rights Amendment. So the amendment that did take kind of longer than this 7-year time span is the 27th Amendment. So the 27th Amendment was originally part of the proposed Bill of Rights, right? So the Bill of Rights, as we know them today, is 10 amendments. It was originally 12. The 27th Amendment was one of those original 12. So it, was kind of proposed. It obviously didn't make it. But what happened was in 1982, there was a student who had an assignment to write a paper. He was a college level student, had an assignment to write a paper about an amendment that could make it through the entire amendment process. And when he was doing his research, he found a list of amendments that had not been ratified. And he found the language of what would become the 27th Amendment. And his central argument to this was that there was no time limit. So even though it was proposed, in the late 1700s, that there's no time limit, so theoretically it could still get the final couple of states that it needed and be ratified. So he originally got a C on the paper. So students take heed. So he got a C on his paper. But then kind of through his research and through kind of really taking up the cause, he decided that he was going to write letters to legislatures across the country. But there was a senator in Maine who, really kind of pushed for this amendment to be passed. So the language of the 27th Amendment itself is, I'm trying to find it right now so that I read it exactly. So it allows for no state, let me get it. I want to make sure that I'm reading it right. So it is, All right, I'm going to find it for everybody. So because I don't want to get it wrong. Okay, here we go. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. So nobody can get a pay raise until the next election. So through it all, this particular student, Gregory Watson is his name. He, kind of campaigned and talked with members of Congress to finally get it ratified. So the amendment itself was ratified in 1992, over 2 centuries after the first Congress proposed it to the states. So it took a little over 202 years for this amendment to get ratified. Now, this is far from the norm. Most of the amendments fall within 1 or 2 years, if not less. So there certainly is this kind of very loose, not even really precedent for it. There's almost like just an anecdote of it happening before. But it is because of this that we start to see these timelines, these deadlines placed on the amendments. But it's worth mentioning that these are imposed by the legislative branch. They're not proposed by the Constitution itself. So just kind of an important distinction that as you move through kind of working through and sifting through all of this information, to understand that that's where this comes from. And as we always do at the National Constitution Center, to go back to the Constitution itself and see what exactly it says about that whole entire amendment process.
Well, this is a wonderful lesson for students about the power of doing your homework, even if you only get a C on a paper like that. And as I recall, covering the White House and Congress during that period of time, there was public unhappiness that members of Congress wanted to raise their own salaries. And that, as I remember from the original Bill of Rights, I think that you can't raise your own salary was like number 1 or number 2, and got pushed down. But thank you for sharing that. I think that's a wonderful lesson. We only have a few minutes left, and while I'm looking to see if we've got any last minute questions coming in, let me see. Oh, here we go. This is from Dr. Shobha. I hope I say this correctly. Dr. Shobha Rajgopal, who writes this: it would be a huge mistake for feminist organizations to step back from this important amendment simply because the language would result in going all the way back to the beginning and starting the ratification process over again. She says we must be aware that the backlash era is clear with many other current controversies on reproductive rights. It might as well result in several states stepping back and rescinding their support. And this goes on to say we are way behind many other countries of the developing world on this and many other issues regarding gender justice. That resonates with you, Kimberly?
Oh, absolutely. Absolutely. I mean, thinking about where we are in the world, compared to, most, as they say, first world countries, we are, very low on the totem pole of constitutional equality compared to our peers, and the rights of women as are not protected or are not specifically spelled out in our documents, in our governing documents, as they are in the majority of the other countries in the world. So it is, as we've been seeing, and part of the argument of recent times is, as we have been, trying to instill democracy and support countries around the world, people have pushed back and said, well, what about how you treat your women? And that is a very valid argument in this space and at this moment. So by being able to actually codify the Equal Rights Amendment, be able to move this country forward, we will stand with our peers in this space. One thing that I wanted to bring in, particularly as we think about the words in the text of the Constitution right now, is to actually quote Justice Antonin Scalia, who said, "Certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. Nobody ever thought that that's what it meant. Nobody ever voted for that." So it is really, it just lays out that it's not in there that you have to discriminate, but it's also not in there that you don't. So we need to get rid of the ambiguity and codify the Equal Rights Amendment.
Well, we are running short of time. I do want to get a chance to ask both of you to to kind of sum up with a kind of a broader sense, and especially for this student audience and their teachers who are watching this. What is it? I'm going to start with Sarah. What is it that the students watching today should realize that this is not an centuries old issue? This is very much having to do not only with their past and the present, but their future. What would you like students to carry forward with them as they watch this process unwind over the coming months and possibly years? Sarah?
So thank you, Anne. And I think part of the kind of closing remarks that I've been thinking about over the past couple of weeks is that this issue of any issue of equality is never an old issue, right? It's always current. It's always today. And with that, I mean, we don't always get to talk about that in terms of a constitutional amendment, right? That's kind of one of the biggest things. So what I have kind of found and what I would love to share with the students is to recognize that, you know, the Constitution itself and the amendment process is an important process, but it doesn't just apply to the national government. And kind of throughout this whole discussion and throughout the history of the ERA in general, we've been talking a lot about states, right? They play a huge role in this process overall. But within that, they also kind of have their own constitutions, right? State constitutions. And it's just worth noting some of the things that I found that since the 1970s, 25 states have their own ERAs in their own state constitutions, with 4 more states in the process of considering it. So that's not to say that a national amendment is not important, but I do like to share that too, because as we've seen, this national amendment process can be a lengthy one, but it certainly doesn't have to necessarily inherently be a discouraging one. So I just kind of found some of the language of these states, because sometimes they mirror everything from the Declaration of Independence to the proposed ERA itself. And I found 2 that were kind of impressive in my mind that I wanted to share. So for instance, Iowa in 1998 said all men and women are by nature free and equal and have certain inalienable rights. So obviously we're conjured up with these ideas of the Declaration of Independence. Montana in 1973 said the dignity of the human being is inviolable. No person shall be denied the equal protection of the laws. So I just encourage everybody to kind of look to see what your state legislations might say. I think my wonderful home state of New Jersey is one of the 4 that's adding their ERA to their state constitution. But it's, again, not kind of the end of the story just because your state has it in their constitution, but definitely something that is worth exploring.
For you Kimberly, I think my question to you is, for these young people who will be moving into society, they are our future leaders, and you have such experience in actually being on the front lines, the advocacy, and working with the practical political landscape. What do you want the students here to think about doing and being attentive to in the weeks and months or however long it takes, not just for the Equal Rights Amendment, but this kind of civic responsibility and engagement, the importance of it?
Well, it is, regardless of the issue, raise your civic voice. Be in touch with your elected officials, because at the end of the day, they work for you. We hire them when we vote for them, or we fire them when we vote them out of office and vote for someone else. And it is, voting is the first step of participation in our democracy. And it absolutely cannot be the last step. As we are, have been discussing this constitutional amendment, it has moved through Congress because their members of Congress, they heard from their constituents, their support for the issue, their lack of support for the issue, and they voted accordingly. So be engaged in the process, pay attention to what's happening in your state houses, in the halls of Congress overall, and raise your voice. Let them know what you think. write a letter, send an email. They so often don't hear enough from particularly young people about the issues that are of concern to them and ways these laws will impact your life. I mean, I have two children that are under the age of 15. So I'm doing this thinking about what is their future going to be? How do I make sure that my son and my daughter are on equal footing in everything that they do? So make sure that you are part of this process. It is your duty as an American to participate, and your duty and your obligation, and just make sure your voice is heard.
I will echo that as now a grandmother of 9 under the age of 8 and their future as well. I want to thank both of you so much, Sarah and Kimberly, for really bringing to life so many of these issues. And also a big thanks to our hosts from the Gerald Ford Foundation for inviting us to come and share these thoughts today. I hand it over with our thanks to Joel Westfall.
Thank you very much, Anne, Sarah, and Kimberly. Thank you very much for your insight today on the Equal Rights Amendment. I think we all really enjoyed the extremely great discussion. And I believe that Mrs. Ford would have thoroughly enjoyed today's program, as I know the students did today as well. I'd also like to thank the student audience for your questions, which many of them were very good. I would like to remind the students today that you are tomorrow's leaders, and I believe that today you demonstrated that we are all in really good hands by your participation in this great program. Just to remind everyone, a recording of today's program will be available online, and tonight at 7 p.m. we'll be hosting a public version of this program, and there is still time to RSVP for that. Programming like this is possible thanks to the Friends of Ford. And today, a special thanks to the National Archives Foundation and the generous support of Maggie and Robert Boujardé for co-sponsoring of these events. Thank you very much and have a great afternoon.